Hi, this is Dan Smith with DPS Legal Counsel, and welcome to today's video and audio podcast of Legal Scrubs. Legal Scrubs is my podcast where I talk about issues of interest to health professionals in connection with running and operating their practices. And today I want to talk about a recent development. Just came out last week from the Office of Inspector General and the Department of Health and Human Services. The OIG's office issued an advisory opinion. This is advisory opinion number 2307. This was issued on October the 10th, 2023, and was posted by the OIG's office on October the 13th of 2023. So today is October the 19th, so this is within the past week. What this involves is a situation, someone asked for an opinion from the OIG's office with respect to a proposal to have a compensation arrangement with their physicians in their multi-specialty practice. What this was, this practice has 11 physicians in their multi-specialty practice. These physicians are employees of the practice, and the practice owns and operates two different ambulatory surgery centers where the doctors who are in the practice perform outpatient surgeries. And what the practice wanted to do was, what they were asking the OIG to render an advisory opinion on, was whether it was acceptable to compensate as a bonus physicians in their practice who performed outpatient surgeries at these two ambulatory surgery centers by paying them a portion of the net profits from the facility fees that the practice got with respect to the outpatient surgeries that the doctors were doing at their ambulatory surgery center. So in other words, Dr. 1 or Dr. 2 might do an outpatient surgery at one of the ambulatory surgery centers, and at the end of the quarter, with respect to the surgeries that doctor did at the ambulatory surgery center, the practice would have some net profits from facility fees that were paid for those surgeries, and they wanted to pay the doctor a percentage of that. So in fact, what they were proposing to do was to give a bonus to the physicians in their practice in the form of 30% of their net profits from the facility fee that the surgery center got in collections attributable to the physician's procedures that were performed at the surgery center. And the question was, is this acceptable? The big question that this raises is with respect to the Federal Anti-Kickback Statute. Now, the Anti-Kickback Statute, as you probably know, it makes it a criminal offense to knowingly and willfully offer, pay, solicit, or receive any remuneration to induce or in return for the referral of an individual for the furnishing of or arranging for the furnishing of any item or service that's reimbursable under a federal health care program. And so it was understood, and it was also put forth in this the application for this advisory opinion that yes, the services that these doctors were performing and doing their outpatient surgeries, some of these were reimbursable under federal health care programs. So by doing these surgeries and getting net profits from these surgeries at the surgery center, were they running afoul of the Federal Anti-Kickback Statute by getting some remuneration for making referrals of their patients to these surgery centers? Now, in their analysis, the OIG said that it went through the discussion of the Federal Anti-Kickback Statute, and it talked about one of the exceptions to the prohibition that the Federal Anti-Kickback Statute puts in place, and that is there is an exception statutorily and also regulatorily for remuneration paid to employees, bona fide employees of a practice. And so these doctors were all employees of the practice, and even though they were referring patients to the surgery centers and then getting net profits from the surgery center for doing those outpatient surgeries, the OIG's office said because they were bona fide employees, they fell within the exception, the employee exception from a violation of the Federal Anti-Kickback Statute. So, in other words, the OIG's office, in this advisory opinion, blessed this proposed compensation arrangement, so that this practice, this 11-person multi-specialty medical practice, could in fact bonus to their employed physicians 30% of the net profits attributable to the facility fees for the surgeries that these doctors performed at the surgery center. This is a great advisory opinion and will help practices that have ambulatory surgery centers stay in compliance with the law and make sure that the bonus arrangements they may have with their doctors comply with the Federal Anti-Kickback Statute. Now, it's interesting that in this advisory opinion, the OIG noted that these doctors were all bona fide employees of the practice, and they were getting a bonus with respect to their outpatient surgeries for the services they rendered in their status or in their role as employees. This was employee compensation. Now, the OIG noted that it might be a very different answer, and it might be prohibited under the Federal Anti-Kickback Statute if a practice was trying to compensate non-employee physicians, such as independent contractors who perform surgeries at an outpatient ambulatory surgery center, by doing this type of thing. So, for example, if a practice had some non-employed physicians that performed surgeries at a practice's ambulatory surgery center, it would probably, based on the language in here and just following the way the anti-kickback statute works, it would probably be prohibited for that practice to pay this kind of bonus to a non-employed physician, an independent contractor physician. The advisory opinion also noted that these surgery centers were owned by and operated as divisions of the practice. And so these payments to these doctors was employee compensation to them. These were not paid to them as owners or as an owner distribution from the surgery center itself. These were paid as wages, essentially, employee compensation to these doctors. So if a practice, let's say, had a ambulatory surgery center for its doctors, but let's say the doctors, rather than the practice owning the surgery center, the doctors in the practice directly own the surgery center. Then if the money then goes to the doctors from the surgery center, same kind of dollar amounts we're talking about, let's say 30% of the net profits of the facility fee attributable to their surgeries, but it's paid as a distribution to them as owners, then they would not meet the employee exception. So that type of arrangement, that type of structure might very well run afoul of the Federal Anti-Kickback Statute. So as far as planning for medical practices, it may make sense to look at this advisory opinion and perhaps structure the ownership of a surgery center to be the operating division of the medical practice, rather than having the doctors own directly ownership interest in the surgery center, and to pay them bonuses based on their work at the surgery center, but pay them that as employee compensation, so that they're not getting the dollars as a owner distribution. So that's all very helpful. It's all very interesting. Again, this is advisory opinion number 2307. If you are a physician in a medical practice, maybe a multi-specialty medical practice like the one in this opinion, and you have an ownership, or the practice has an ownership with an ambulatory surgery center, this could be a very interesting opinion to you, because it may show how properly structured you can have bonus arrangements that take into account the work that you do as a doctor at the surgery center without running afoul of the Federal Anti-Kickback Statute. But at the same time, it also shows that you have to be careful how you structure the payments. They need to be coming in as payments for employee compensation and not owner distributions, and certainly not as payments to non-employee physicians like independent contractors. Okay, I hope that helps. And if you have any questions, please let me know. We'll see you next time on Legal Scrubs.